To the administrator of the United States Small Business Administration, you are being summoned in a civil court action. A lawsuit has been filed against you. Within 21 days after service of this summons on you, or 60 days if you are a United States agency, you must serve upon the plaintiff an answer to the attached complaint, or otherwise a judgment of default will be entered against you. Ho, 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 folks, here we go. The administrator of the Small Business Administration just had a lawsuit filed against him by multiple different companies working together over the EIDL grant program. If you're not yet familiar with the EIDL grant program, let me give you a quick rundown. Basically, the CARES Act, the stimulus package that was passed on March 27th, included a provision that said, hey, if you have a small business, even if you are your own employee, if you have a small business or a side hustle, and you put your information on the small business website, attesting to the fact that you have been affected by this pandemic and that you need help, you can request an advance of up to $10,000, and the SBA must give it to you within 3 business days. Well, obviously, I've also made videos not only introducing this, but I've made videos talking about how the SBA kind of bait and switched everybody, and we kind of threw up our hands going, all right, whatever, it's just like classic government, promise us $10,000 grants within 3 days and give us $1,000 grants per employee up to $10,000 within 3 weeks. It's not exactly congruent with the law. Well, now we actually have a lawsuit. And so what I'm going to do is I'm going to break down what's in this lawsuit. I read the entire lawsuit. I have the entire lawsuit here. I'll share the screen with you. And then I'm going to break down the implications for you. And if you have not yet filed or applied for this EIDL grant, stay tuned because I'm going to explain the implications for you as well. Let's get into it. So here you go. Here's the lawsuit. You can see the first defendant is the administrator for the Small Business Administration. Then we get to Maria Lopez, the acting United States attorney for the Middle District of Florida. Then we have William Barr, United States Attorney General, who's also being sued. Then take a look at all the parties part of this lawsuit. I mean, you've got Land and Sea LLC, Marine Services. I'm pretty sure I saw like a barber shop and Safari Trading, a builders, marine sales, a bottler, a soup kitchen or something like that, cigar lounge. Look at this, downtown debauchery is in the lawsuit. Oh my gosh, these are a lot of different, look at that, a title and escrow company is in this as well. My goodness, so a lot of people hopping together in on this lawsuit here. And it all stems from this clause right here, which this is where the debate is. And I want to see what your opinion on this is. In fact, after I read this, I'll do a little poll. I'll point it up to you and I'd encourage you to vote on it. I'm kind of interested to see what you think and then we'll see where this is going to go. But anyway, this is the part of the CARES Act that actually is sort of the matter at dispute. And so I've highlighted it here. It basically says that during this period, if you were affected, you can request from the administrator, from the SBA, that you get an advance in the amount requested. That's very important. Notice I circled that in red there because it says that you're the one who asks for the amount requested. And then right below that, it says the amount of an advance provided under this subsection shall not be more than $10,000. And so the debate is, some people are reading this to say, okay, well, the SBA can determine how much of an amount you get. But most people, particularly businesses, are reading this going, no, I get to determine how much I ask for, and the SBA is required to give me not more than $10,000. There's nothing in the actual CARES Act that says this $10,000 grant or completely free money for small businesses that's supposed to be given within 3 days is conditioned upon how many employees you have. At least nobody's found it. The only loophole that I think the SBA is hiding behind here is the fact that it says the amount of the advance provided under this subsection shall not be more than $10,000. To which, again, everybody's replying going, well, yeah, but I'm asking for $10,000. So anyway, then the lawsuit goes into basically just explaining what I told you, and we get some letters here from actual congressional representatives and senators who say things like, here's a good quote. Here's one that says, a congressman wrote this letter on April 8th. As you are, this is to the administrator of the SBA. As you are aware, the CARES Act permits small businesses that apply for an EIDL to request an immediate advance of $10,000. And it's not just this congressperson. There have been multiple people from Congress sending letters to the SBA going, hey, how you guys doing on sending out those $10,000 checks to small businesses? This is like a stimulus package to the big majority of our employers in our country. Let's help the little guy for once. Instead of just focusing on bailing out the airlines, let's help out the little guy and give him some money when they need money. Let them ask for it and let's give it to them so at least people can pay their bills. And this is kind of important because remember, it's the people in Congress who came up with this bill and they voted on the bill. And if people in Congress are going, hey, so when are people getting their $10,000? And the SBA is like, what do you mean? We're giving people $1,000 per employee up to $10,000. It's not really congruent with the spirit of the bill. In fact, here's a reference to a letter from Congress people saying, hey, like the PPP, that Paycheck Protection Program the SBA keeps referring to, that's not going to be a good fit for everybody. In fact, I did a video today on why Shake Shack actually gave back their $10 million PPP loan. It's because the loan program's a sham. It's like a total scam in terms of the whole forgivable nature of it, at least from what we can tell by looking at some loan agreements. Anyway, here's another quote from a congressperson's letter that $10,000 should be released within 3 days. And then you see things like in complete defiance of the law and specific directive of Congress and without discretionary authority to do so, the administrator did not provide the initial EIDL grants within 3 days of applicants applying for relief as required under the CARES Act. All right, so I think we're kind of caught up on the background. And then of course, the SBA issued multiple letters going, hey, the advance will provide $1,000 per employee because, well, they say to ensure the greatest number of applicants can receive assistance during this challenging time, the amount of your advance will be determined by the number of pre-disaster employees you have. In fact, here is such a letter directly from the SBA. And just to be clear, here's another one of those congressional letters. The CARES Act permits small businesses that apply for the emergency injury disaster loan to request an immediate advancement of $10,000 that is distributed to the business within 3 days of that application. Keep in mind that that portion of the law, by the way, only requires a credit check, and it doesn't even say that you have to have like good credit. It just says credit check, and I personally speculated that that was because they didn't want to give the same people with a bunch of different businesses multiple of the loans. But anyway, most people ended up getting limited to however many employees they self-attested that they put in on that form. So if you said you had one employee, you got $1,000, unless you missed the whole application window to begin with. All right, so now let's talk about what a lawsuit like this means and what we should do. Let's start with what it means, and then I'm gonna give you recommendations, which those recommendations are gonna be really important. But in terms of what this means, it's difficult to say. If this were a private company, we would start opening up settlement negotiations probably within the next couple weeks. Unfortunately, given that this is a private group of individuals suing a government agency, the whole lawsuit process is a complete disaster. Usually, before you can even sue a federal agency, you have to go through that federal agency's internal dispute process first. In other words, it's kind of like if you're pissed off at the SBA, you have to complain to the SBA, go through whatever complaint ringer they want to put you through, and then after you get a decision from that administration, only then can you actually file a lawsuit. So if they didn't do that in this lawsuit, and if I'm correct that you have to go through the agency first and get denied, this whole lawsuit might just get tossed, which sucks, but this does put the SBA on very clear notice that, yo, this is messed up, and people are gonna keep fighting this. So, what does this mean for us going forward, and what should we be doing and thinking? Well, number one, if you have not yet applied for the SBA's COVID relief, I highly recommend you do that if they open the portal back up. They're expected to open that portal back up so you can apply for your free $1,000 or $10,000 grants, again, depending on how many employees you put in. And I'm not encouraging you to lie, but remember, you are your own employee, so at the very least, put one if you have a small business or side hustle. But anyway, that portal was expected to hopefully be open again on Wednesday, but now, well, Congress is being Congress, and we might not see it open until Friday or maybe early next week. But what I encourage you to do is bookmark the link that I'm going to put in the description down below so that you can keep checking to see if that portal opens back up. And that way you could apply as soon as it's open again. Because here's the thing, if you've already applied and you've already gotten maybe $1,000 or whatever, or you haven't yet applied, but you're going to apply, if this lawsuit actually prevails and if Congress comes through and goes, wait a minute, yeah, like we heard about this is messed up, or maybe they clarify it in a future bill, my guess is there's quite a strong possibility they could go through all of the records of people who received the initial grants, and they might go, ooh, sorry, yeah, we gave you $1,000, here's the extra 9. No guarantees, okay? No guarantees. I'm just saying, like, at the very least, even if you have a small side hustle and you're like, is it gonna be worth it, me filling out that portal again? Yeah, because if you think you're only gonna get $1,000, at least there's a little bit of hope that you might get the extra 9 in the future. Again, no guarantees, but the fact that we've got a law firm and a bunch of businesses here that actually put a lawsuit together is definitely going to highlight this issue, not only to representatives and other Congress folks, but also it's gonna highlight that people are pissed about this. So I would recommend, if you want a way to sort of express your frustration with this, send a message or an email to your local representatives and senators. Just Google Senator for Ventura County, Representative for Ventura County, whatever your county is, and mention this. Hey, I heard there's a lawsuit about the EIDL grant. I just wanted to let you know, like, y'all might want to look into this. This is BS. Like, we were supposed to get 10K grants and we didn't. So really interesting. I can't say I'm like super hopeful, but the more attention we get to this, the better. And I gotta ask you as an audience, really, what do you think? Just looking at that verbiage one more time, it says, make sure you go and use the links down below and deposit $100 with Webull to get your 2 free stocks valued up to $1,400. I'm kidding. I mean, you should do that. It's right next to life insurance and the links to my programs. But anyway, remember what it actually says. In the amount requested by applicant. That's the advance. The applicant may request the administrator provide an advance that is subject to paragraph 3, which is the amount, in the amount requested by such applicant to such applicant within 3 days after administrator receives an application. The amount, and then paragraph 3, the amount of an advance provided under this subsection shall not be more than $10,000. I mean, to me, the way I read it is I get to request an amount. If I request $5,500, as long as it's in accordance with line 3, which is, or paragraph 3, which is the amount shall not be more than $10,000, me requesting $5,500 is not more than $10,000, well then to me it sounds like I should get my $5,500 because that's the amount I requested and it's not more than 10 grand. But I guess it's up to a judge to decide, but make sure you use that little poll link in the little bubble above and let me know what you think.